You went to sleep last night thinking your immigration case was moving forward. Maybe you have an attorney. Maybe you have a court date scheduled. Maybe you even had a bond hearing already and you were released while you wait for your case to be decided. And now, this week, a court ruling has quietly changed the legal ground beneath your feet. Not a new law passed by Congress. Not a new executive order with a press conference. A court decision. A legal redefinition. 4 words that are now being applied in a completely new way. And those 4 words, applicant for admission, could determine whether you go home to your family tonight or whether you are held in a detention facility while your case plays out in immigration court. This is not a rumor. This is not a worst-case interpretation from a panicked corner of the internet. This is what immigration attorneys across the country are waking up to right now, in early March of 2026. And if you have a pending immigration case, if you have ever had any interaction with immigration enforcement, or if you are living in the United States without a current, valid status, this ruling affects you in ways that may not be immediately obvious. Stay with me through this entire video, because the details here are where everything changes. While social media is full of noise about this ruling, most of what you are seeing online is incomplete, mislabeled, or missing the legal context that makes this so significant. We are looking at the official language. We are looking at what the courts actually said, what it means under immigration law, and what it means for your life specifically. And as always, remember, I am an analyst walking you through the system. This is educational content, not legal advice. Your specific case has specific facts, and only a licensed immigration attorney can evaluate what this ruling means for your individual situation. Please do not make any decisions about your case based on this video alone, but do use this video to understand what questions to ask and why asking them right now is urgent. Let's start with some foundation, because you cannot understand what changed without understanding what the law said before. Under United States immigration law, there are 2 fundamental categories of non-citizens. There are people who are seeking to enter the United States, meaning they are at a port of entry, a border crossing, or they have just arrived and haven't been formally admitted yet. And then there are people who are already inside the United States, who have already been admitted, either legally on a visa, through a green card, through asylum, or through some other formal process. That distinction, the line between someone seeking entry and someone already admitted, has always been one of the most important lines in immigration law. Because the rights and protections available to you depend enormously on which side of that line you stand on. People who are considered applicants for admission, meaning they are at the border or being processed for entry, have historically had far fewer procedural protections. The government has broader power to detain them, to turn them away, and to do so quickly. People who are already inside the country who have already been admitted in some legal capacity have traditionally had more protections, including, critically, the right to a bond hearing, the right to ask an immigration judge to evaluate whether you are a flight risk or a danger to the community, and potentially to be released while your case is decided. That bond process has been a lifeline for thousands of families. It is the difference between fighting your immigration case from home, from your job, from your community, and fighting it from inside a detention facility. What this recent court ruling has done is blur that line in a way that legal experts are describing as a fundamental shock to the system. Here is where it gets complicated, and this is the part you absolutely cannot skip. The court has now expanded the definition of who qualifies as an applicant for admission, and in doing so, it has opened the door to treating people who are already inside the United States, people who may have lived here for years, as if they were just arriving at the border for the first time. What that means in practical terms is that certain categories of non-citizens who were previously eligible for bond hearings may no longer be. They can be held in immigration detention indefinitely while their cases move through the court system, without a bond hearing, without a judge evaluating whether detention is even necessary. Think about what that means for a moment. Immigration cases routinely take months, sometimes years. We are talking about the possibility of people being detained for the entire duration of a legal process that has no guaranteed end date, based on a redefinition of 4 words in a statute. Most people hearing about this ruling are focusing on the headline, "No more bond," and moving on. But the most important detail, the one that most people are missing entirely, is the question of who this new definition actually captures. And the answer is broader and more unsettling than many people realize. The expansion of the applicant for admission definition does not only apply to people who just crossed the border last week. Legal arguments are now being made that this definition can apply to non-citizens who entered the country without inspection at any point, meaning people who entered without going through an official port of entry, even if that happened years or decades ago. It can potentially apply to people whose legal status has lapsed, even if that lapse was minor or unintentional. It can be argued to apply to people whose asylum claims were denied and who remained in the country during an appeal. And in some interpretations being tested right now, it may apply to people who had temporary protected status or other forms of humanitarian relief that the current administration has moved to terminate. If any of those circumstances describe you or someone you know, the urgency of speaking with an attorney is not theoretical. It is immediate. Let me bring this to a real situation, because I want you to feel the weight of what we are discussing. Imagine a man. Let's call him Marco. He came to the United States 15 years ago. He entered without documentation. But over the years, he built a life. He has American-born children. He has paid taxes. He has a pending application before the immigration court based on a claim of cancellation of removal, a legal process that has been moving slowly through the backlogged court system. Last year, Marco had a bond hearing. A judge reviewed his case and determined he was not a flight risk, not a danger to the community. He was released on bond and has been living at home with his family while he waits for his court date. Under the previous legal framework, Marco's situation, while difficult, had a defined path. Under the expanded definition of applicant for admission that is now being tested in courts, Marco could be redetained. The legal basis for his bond could be challenged, and his family could find themselves separated not because anything in his case changed, but because a court redefined a category that now captures him differently than it did before. Marco's story is not unique. There are hundreds of thousands of people in similar situations across this country right now. Let's look at the facts, not the fear. Here is what is confirmed. Courts have issued rulings that expand the interpretive scope of who qualifies as an applicant for admission under the Immigration and Nationality Act. These rulings are being cited by the government in ongoing detention cases. Immigration attorneys in multiple states have already reported clients being affected. The legal challenge to this expansion is active. This is not settled law. It is contested law. And contested law, by definition, means the outcome is still being fought over in courtrooms right now. Here is what is not confirmed and what you should be skeptical of. Anyone telling you that every single non-citizen in the country is now subject to indefinite detention is overstating what the rulings say. Anyone telling you that bond hearings have been completely eliminated across the board is wrong. The situation is more targeted, more technical, and more dependent on individual case facts than those sweeping claims suggest, which is exactly why a blanket panic helps no one. But a specific, informed response to your specific situation is everything. And now, the 3 things you need to do, not eventually, this week. The first thing is to contact an immigration attorney and request a case review specifically focused on your detention and bond eligibility status. Tell your attorney you want to know whether the recent court rulings on the definition of applicant for admission affect your case. Use those exact words. If your attorney is not aware of these rulings, that is itself important information. You want someone who is tracking these developments in real time. If you do not have an attorney, contact your local legal aid society, your nearest AILA member attorney, or an accredited representative through a nonprofit immigration organization. Do not wait for your next scheduled court date to have this conversation. Have it now. The second thing is to document your continuous presence and legal history in this country as thoroughly as possible. Tax returns, school records for your children, medical records, employment records, lease agreements, church or community organization membership. Any document that establishes a timeline of your life in the United States is relevant. If your bond eligibility is ever challenged, the evidence of your ties to this community, your roots here, your family connections here, is what an attorney uses to fight for your release. Have that evidence organized and accessible. The The third thing is to sit down with your family and make a plan, not because something is definitely going to happen, but because families who have a plan are in a fundamentally different position than families who don't. Who has legal authority to care for your children if you are temporarily detained? Who is the first person your family calls? What is the name and phone number of your attorney, written down somewhere every adult in your household can find it? These are not morbid questions. These are the questions that responsible families in uncertain times ask and answer together. Here is the larger truth that this ruling points to. We are in a period where the legal definitions that immigration law has operated on for decades are being actively contested and in some cases rewritten, not by Congress but by courts. And court decisions can move faster than public awareness. They can change your legal position before you even know a ruling has been issued. That gap, the gap between when something changes legally and when the people affected by that change find out about it, is where the most serious harm happens. It is where families get separated without warning. It is where people lose rights they didn't know they were about to lose. It is where the system moves faster than the community it is affecting. Closing that gap is the entire reason this channel exists. Immigration law in 2026 is not static. It is moving. It is contested. It is being argued in federal courthouses from California to Florida to New York every single day. And the people who are most protected in this environment are not the people with the most money or the most connections. They are the people who are paying attention, who are informed, who know what questions to ask and who to ask them to. If this video helped you understand something that was confusing, if it gave you one concrete thing you can do to protect yourself or your family, then please subscribe to this channel right now and turn on your notifications. Because the next ruling, the next policy shift, the next legal development that could affect your case, it is not going to announce itself. It is going to happen quietly, in a courtroom, in a government memo, in a policy update, and you deserve to know about it before it affects you, not after. Stay informed, stay organized, and protect your family with knowledge.